start my presentation not so fascinating like the presentation of Mrs. Starabouillon, but I try to share my thoughts concerning the another issue, actually, this of regulating artificial intelligence, and the subtitle is European Answers to Global Questions with question mark, I must say. I'm not very sure that I can change. Can you see now? The next? Okay. The question is, why this topic? AI and data protection issues, in my approach, not only in my approach, are strictly interrelated. Discussion of the GDPR's effect on AI tends actually to focus on automated individual decision-making, and Professor Uta Cole will speak about Article 22. But it will also have major effects on any other aspects of AI systems, including the secondary use, disclosure, and the retention of existing personal data for the purpose of constructing training sets, including disputes over anonymization and the use of personal data collected by AI systems for new training sets. Although the AI Act does not apply to controllers or processors as such, it will in effect apply to situations wherever personal data, as defined by the GDPR, is used in AI systems as defined in the draft AI Act, and where this may pose unacceptable risks. This Act will pose obligations going beyond those in the GDPR. Some controllers or processors under the GDPR will therefore have extra obligations imposed on them through the AI Act. Which is the main content and the goals, the regulatory goals of AI Act. The European Commission released this highly anticipated Artificial Intelligence Act in April 2021. The EU and member states have stressed the need to address both opportunities and societal challenges raised by artificial intelligence. And the question was, how can we guarantee that AI is designed and used responsibly? How can we establish ethical and legal rules to protect people, avoid bias, and help establish fair and adequate liability systems? Actually, how should we regulate AI without hindering innovation? We see that this dilemma is also present in this discussion: protection against innovation or vice versa. The explanatory memorandum accompanying the official text of the AI Act frames the aims for the new law. AI should be a tool for people and be a force for good in society, with the ultimate aim of increasing human well-being. Rules for AI available in the union market or otherwise affecting people in the union should therefore be human-centric, so that people can trust that the technology is used in a way that is safe and compliant with the law, including respect for fundamental rights. The proposal follows a wave of previous EU policy documentation addressing AI and adopts actually the ethical guidelines proposed by the high-level expert group. Another key aim of the EU is this of AI harmonization. By its nature, as a regulation, AI Act will be a regulation, not a directive. This act will become directly applicable in all EU member states, which should help ensure that the national approach to AI will not fragment across the single market, disturbing its proper functioning. One of the main issues discussed also in the consultation, actually a vital consultation, was how far to go with the regulation without hindering innovation. Which are the main regulatory choices? The Commission has, in its proposal, distinguishes different risk levels. It's a so-called risk-based approach, also well known from the GDPR. AI practices, which we adapt to mention, are categorized in 4 categories: unacceptable risks, high risks, limited risks, and minimal risks. This risk-based approach seems convincing in its common approach for internal market-based regulation and aligned with the view that ethics benefits the market and not vice versa. The legal framework for AI addresses the risks generated by specific uses of AI and focuses on imposing obligation with respect to such high-risk use cases, mainly, including obligations to undertake relevant risk assessments, have in place mitigation systems such as human oversight, and provide the transparent information to users. The draft AI Act contains obligation of a procedural or managerial nature. The proposed regulation places confidence in procedure to cope with the high risks of artificial intelligence. That means assessment of conformity, registration of high-risk AI systems in a new EU-wide database. And we must say that the trust in procedure, the focus in procedure goes so far that substantive issues are addressed mainly on a procedural way. Member states will be required to appoint one or more national competent authorities to enforce the regulation at the national level in coordination with existing sectoral legislation. And this is a focal point, I must say. And I know that the EDP, the supervisor, the European Data Protection Supervisor, in a common position with EDPB, has given his guideline to appoint the data protection authorities as competent authorities, but this is actually a controversial issue. Like in the GDPR, we have a very interesting sanction system. In this case, the EU Commission is proposing, we could say, a draconian penalty regime in case of non-compliance with the AI Act. And the proposal has presented potential penalties of high severity, even beyond those of the General Data Protection Regulation, with fines potentially reaching 30 million euros or 6% of global turnover, whichever is higher, for the most serious violations of the new AI regime. These numbers would catch the attention of global boards and other stakeholders in Europe and, of course, and worldwide. And I think this is also a main point, a main focus of the new legislation. The proposed legislation has been designed to be complementary to cross-sectoral EU legislation, and we have to keep in mind that this time also Digital Services Act and Digital Markets Act and Data Governance Act are part of the legislatory initiatives of the EU. The AI Act incorporates the character of ethical norms that lack the commitment of hard law and extends the life of such norms and continues their approach of indulgence. It represents the most ambitious attempt to regulate AI technologies today, setting out a cross-sectoral regulatory approach to the use of AI systems across the European Union and its market. It addresses main concerns related to artificial intelligence of the machine learning type, essentially, mainly, namely bias due to input data, opacity that may hamper predictability, explainability, and accountability, and last but not least, the vulnerability to misuse. The AI Act refrains from taking on broader concerns with which modern artificial intelligence is often conflated, namely market power, market position, general effects of technology, etc. However, this restrictive regime does not totally close the door to novel developments of AI. Instead, the text of the regulation, at the time of writing at least, indicates that this piece of legislation aims to create a legal framework that is innovation-friendly, future-proof, and resilient to disruption. It does so by encouraging national competent authorities to set up regulatory sandboxes. According to the European Data Protection Supervisor website, the AI Act is the first initiative worldwide that provides a legal framework for artificial intelligence. Regardless of whether this may be true, we have, for example, the US National AI Initiative Act, which became law in January. The AI Act is obviously one of the most influential regulatory steps internationally. This is actually another key issue. The main focus on my presentation is the extraterritorial scope of AI Act. The AI regulation will apply to private and public sector actors that are providers or users of an AI system outside the European Union. That means also in UK. The AI Act will affect privacy protection because both the GDPR and the AI Act have extraterritorial scope, but each of them has different criteria for extraterritoriality. The AI Act will extend beyond the contours of the EU due to its extraterritorial scope, applying to providers in third countries who place services with AI systems in the EU single market, as well as to providers whose AI systems produce outputs which are used in the EU. The effects test potentially extends the law reach to companies without a market presence in the EU that use AI systems to process data about citizens resident in EU. This is what is important is whether an AI system or service, for example, a loan management program based on machine learning analysis, has an impact on European citizens and not where the company that provides it or uses it is located. Examples will include any outputs used within the EU resulting from the AI systems in cloud-based services offered by providers outside the EU or by internet-based services of companies located in third countries. Companies outside Europe involved with AI will need to be concerned about coming with this within the extraterritorial reach of the GDPR if they are marketing to EU citizens or profiling their actions. As the Commission explains, this additional extraterritorial scope was required to prevent circumvention of the new regulatory framework. Let me move to another related issue, which is the Brussels effect. As with the GDPR, the more important effect of the EU AI Act is likely to result not from direct legal impact, but from its emulation by countries and organizations outside Europe, the so-called Brussels effect. The Brussels effect leads, under some conditions, of course, to unilateral regulatory globalization, where regulations originating from a single jurisdiction penetrate many aspects of economic life across the global marketplace. The European Commission has portrayed the AI regulation as a defense of European values against less scrupulous AI developers. This has led a number of commentators to anticipate this Brussels effect. That is, like the GDPR, the EU rules for AI could extend too much of the world as international companies comply with the single market's rules and standardize these practices in other jurisdictions. The situation does not occur, of course, without reaction, as Bradford points out. Some commentators go so far to allege that this externalization of EU single market reflects a kind of imperialistic motives. Both the EU But the EU counters this criticism by arguing that this is not engaged in coercion. It's not using force or threats to persuade any company or government to do anything. The particular when the EU is exporting its rules throughout the market-driven Brussels effect. Instead, the EU is simply asking others to play by its rules when operating in its home market and enforcing the norms of the single market equally on domestic and foreign players. This voluntary or semi-voluntary take-up of EU norms by multinational corporations creates what Bradford terms as a de facto Brussels effect. This may subsequently result in corporation asking pressure to their domestic governments to adopt the same norms through regulation, and that could level the playing field with respect to the competitors in the marketplace, which are not so interested in exporting goods or services to the EU. By legislating, the EU hopes to establish a de facto global standard for AI. The GDPR experience demonstrates the advantages of moving early to drive global public policy consideration. But the two, of course, they are not entirely analogous, of course, privacy regulation and AI regulation. However, the impact of the ethical norms on artificial intelligence may be regarded as stronger than international legal theory suggests. The ethical norms were consolidated outside. These ethical norms concerning the AI were consolidated outside of the traditional venues of international law. And as I think it was Kuhner who has observed that when a legal system strives for its standards to be accepted as universal values, it's inevitably engaged in a hegemonic struggle in which it seeks to have its own interests identified with the general interest. Furthermore, the AI will place the EU in a position of leadership by example. This was also the attempt with GDPR. In this case, for the good governance of AI technologies, especially when interacting with other countries at the forefront in the field of AI research and development, like Canada, and of course, also like UK. In this case, too, one may expect that a harmonizing effect similar to that caused by the GDPR. Sorry. Can this lead, that was also a goal of the EU, can this lead to the so-called digital sovereignty? Moral and Timmers define digital sovereignty as the ability to decide and act autonomously on the essential digital aspects of our longer-term future in economy, society, and last but not least, democracy. This can also be described as control over one's governance of the digital age. The first dimension is defined by the EU's goal to set its own standards, rather than having to follow standards that are set by others. Second, the ability to influence others. The vision goes beyond setting standards for itself, also encompassing the idea of persuading others to set similar, if not identical, standards, and its desire to influence the approach to the digital revolution of other global players. Of course, this is a sensible goal given the flexibility of digital technologies and their transboundaries effect. And nevertheless, it pushes, of course, the concept of digital sovereignty beyond the limits traditional associated with the idea, the concept of sovereignty. These new rules will probably not be as harmful and restrictive as some may fear, although there is no doubt that the pandemic has provided an extra impetus for those arguing for sovereignty. But neither they are likely to be transformational for European capabilities. They may They may make European Union, to be more concrete, more sovereign in the nominal sense of establishing rules for European data, but they will not, I'm afraid, make Europe a global leader in data. Is this a global and international? Do we need an international response? The decision to carve out its own bold regulatory direction on AI poses the question of what space is left for an international or a multilateral agreement. The realities of different regulatory philosophies and varying constellation of business, consumer, civil society interests will limit these ambitions and expectations of a transatlantic or international cooperation and regulation. Clark extracted 50 principles for responsible AI, but his analysis revealed that remarkably limited consensus among the 30 sets of principles. And the proliferation of national ethics guidelines, complemented by many private or non-governmental initiatives, has been accompanied by a second development, which is there is a kind of regulatory convergence. Besides this emergence of bilateral cooperation around governance issues, this is the EU and Japan, France and Canada, Germany and India. There are multilateral initiatives to work towards common regulatory standards. To mention the OECD AI principles adopted in 2019, and they are endorsed by more than 40 countries. And there's also this global partnership on AI, GPAI, together, that means EU together with other countries like EU, Australia, Canada, Mexico, Korea. And I have to skip the presentation about United Kingdom to go to reach the conclusion, a kind of conclusion of my presentation concerning if we need and if it would be desirable an AI convention. I was attending a discussion a week ago where it was mentioned that the Cybercrime Convention of the Council of Europe could be a model for an AI convention to avoid patchwork and embed fundamental principles. On one side, regulation by law is required to face adverse impacts on fundamental rights and democracy and societal impacts, of course. And the skepticism towards the competence of other regulatory modalities, such as the market, social norms, technological design alone, at least, or ethical norms, ethical frameworks are can fulfill the same role like the law. The idea of an international convention is not surprising, given the highly globalized and interdependent world economy, the common interest by countries to not only build, but also export AI products and services, as well the common aim to ensure the minimization of the harm to the citizens is present. And the question is this convergence through the adoption of international and multinational legal framework achievable or desirable? The search of a consensus between countries with different values might in practice come down to a search for the lowest common denominator of safeguards that each state around the table, even the one with the least protective standards, can live with. This may in turn lead to an overall lowering of the protection standards for the sake of multilateral agreement, which could not be good news for those adversely affected by the technology. Consequently, regulatory governance can be desirable only to the extent it leads to an equilibrium that offers an appropriate level of protection to secure respect for fundamental rights, democracy, and the rule of law. Does globalization of regulatory requirements standards leave room for choices and different regulation adapted to economic, social, legal, and political situation? A second argument concerns that the caution against regulated convergence at the global at the global level, at a time where the economic, social, legal, and political situation of countries strongly differ. The main question, if I may use a German word here, the Gretchenfrage, the question of Gretchen is, do we have the same values? And if we have the same values, do we make the same choices? Is it possible? Is it desirable to make the same choices? Is it unavoidable to make the same choices? Another concern, and I'm stopping here, refer to the fact that the creation of AI-focused regulation is still at an early stage. AI, it's not a new technology, it's 70 years old, at least. But the increasingly pervasive use, the role of this technology is relatively new. Furthermore, the impacts it can have on us as a member of the society, group societies, in the short and longer term are still not fully understood. But let me say it's better too early than too late. Thank you for your patience and your attention.